Hello, I am Gagan. In this lecture, I will explain the nature of international law. You may change the playback speed of this video from the settings. Please do not forget to subscribe to my channel. There are different types of law subjects. Some are based on statutes. For example, law of contract is based on Contract Act 1872. Some subjects place importance on the case laws. For example, constitutional law. Some subjects are based on theories, for example, jurisprudence. International law consists of customs, theories, opinions of jurists, cases, and treaties. It has no single statute or source that covers the entire subject. International law is also known as public international law as well as law of nations. The term international law was coined by English philosopher Jeremy Bentham. Definition of international law. There are several definitions of international law given by various jurists. Encyclopedia Britannica defines international law as the body of legal rules, norms, and standards that apply between sovereign states and other entities that are legally recognized as international actors. Please do not confuse the term international actors. International actors means international organizations like WTO and UNO, international NGOs like Amnesty International, multinational companies like Apple, Google, and Facebook. Animals and humans are territorial. Have you seen dogs urinating to the trees and poles? Many animals like tigers and lions and even snakes mark their territory through urination. These animals do not allow other animals from the same species to enter their territory. Man also marks his territory by drawing borders, posting flags, and by laying fence. For any country to exist, territory is necessary. Once there is a fixed territory, people can live in that territory, economy flourishes, and government starts functioning. If there is no territory, no country can exist. Law is territorial in nature. The laws of a country apply only within its territory. For example, the Indian Penal Code applies to the whole of India. Indian Penal Code does not apply to the territory of USA. In the preamble of the Indian Constitution, it is mentioned that India is constituted as a sovereign nation. Countries like India, Nepal, Sri Lanka, Pakistan, China, and America are all sovereign nations. Sovereignty means that the government of that country is supreme and there is no external control. Before 1947, India was under the external control of British Crown. Hence, India back then was not a sovereign nation. Let me give an example for sovereignty. China decided not to allow the World Health Organization's representatives even during the coronavirus outbreak. This decision of China was condemned by America. But China said that it is a sovereign nation and it has the final word on who is allowed into its territory. China finally allowed a few WHO representatives in a limited way 2 weeks ago. In my opinion, this was too early. Pun intended. Shashi Tharoor, who is a former United Nations Secretary General, commenting on this issue, mentioned the word global governance, which is an aspect of international law. Every country protects its borders and does not allow foreigners casually. If you have hashtag Wanderlust in your Instagram bio and you want to visit another country, you need to first get permission from that country. That permission is known as visa. Your hassle-free foreign travels owe a lot to international law. Countries have relationship with each other for different reasons like trade, travel, territory, and environmental issues. While these relationships take place, dispute may arise between two nations or several nations. When disputes happen, one contentious question comes up. Which law should be applied? A law that respects all nations and which is acceptable to all needs to be applied. We live in a world where all of us cannot agree whether coffee is better than tea. We cannot agree whether topping pizzas with pineapple is fine. In such a world, do you think hundreds of nations can agree on a single common law that governs the relationship between nations? Each nation has its own form of governance, constitution, a distinct legal system, economic system, values, beliefs, and customs. To have a single law that binds all the nations is unimaginable. This is what makes the nature of international law so interesting. Nature of international law. The first question while discussing international law is whether international law is truly a law or not. John Austin gave the definition of law as follows. He said that law is the command of sovereign and enforceable by sanctions. Sanction means punishment. Let us apply this definition to the Indian Penal Code and examine if it qualifies as law as per Austin's definition. The provisions of Indian Penal Code are in the form of commands and they state what acts are prohibited. IPC was passed by the legislature which was sovereign in the year 1860. If someone violates the provisions of Indian Penal Code, they will face punishment. Hence, Indian Penal Code qualifies as law as per the definition of Austin. Let us now examine if international law qualifies as law according to Austin's definition. When it comes to international law, the rules of international law are in the form of commands. But there is no sovereign authority which made these rules. For example, certain rules in international law are based on customs which were not made by any sovereign authority. There is no punishment given to the countries for violating international laws. For example, America violates the international law, yet nothing happens. For that matter, even China violates many international law rules in a tactful way. For these reasons, Austin said that international law is not a law at all. He said that international law is just positive morality. According to the definition of law given by Austin, international law fails to qualify as law. Austin's view that international law is not a true law is opposed by several jurists. Other jurists have given their own definition of the word law, and they believe that international law qualifies as law according to their definition. Oppenheim defines law as the body of rules for human conduct and made by common consent of the community. According to Oppenheim, the international community makes the laws by common consent of various nations. Oppenheim's justification is that the government of different states recognize international law in practice. Even while breaking the international law, the states do not deny its existence. Rather, they interpret the principles of international law in a different way and deviate from it. Hence, international law is law in true sense, according to Oppenheim. Another jurist, Louis Henkin, says that it is not really about the presence of executive, legislature, or judicial branches. Rather, it is about the international law principles being reflected in the policies of the nations. Let me give an example here. Many environmental legislations in India were made to fulfill the obligations under international agreements on environment. In the case of Vishaka versus State of Rajasthan dealing with sexual harassment at workplace, the Supreme Court took inspiration from the Convention on the Elimination of All Forms of Discrimination Against Women, which is an international agreement. Brierley agrees that international law is violated by the states, but he gives the example of how even individuals do violate the municipal laws quite often. Municipal laws are the laws made by a nation and applicable to its own territory. For example, Indian Penal Code is a municipal law in India and it is violated by many. Professor Stark gives 4 points to justify that international law is law. First point, in the primitive societies, laws existed without formal legislative authority, yet they were not denied the status of law. Second point, international law in the form of lawmaking treaties is in existence today. Third point, authoritative agencies responsible for international intercourse do not regard international law as merely a moral code. Fourth point, United Nations is based on the legality of international law. In conclusion, Austin opines that international law is not a law at all. Other jurists like Oppenheim, Stark, and Brierley consider international law as real law. Of course, international law is weak when compared to municipal laws. Nevertheless, international law is law in real sense. Thank you for spending your valuable time watching this lecture. Please like, share, and subscribe to my channel. If you want more topics in this series, comment below. Wishing you love, peace, and harmony. Thank you.